Welcome back to Legalese 123, where we are covering cases across America. Hello and welcome back to Legalese 123. I'm your host, Missy K. I hope you're having a wonderful St. Patty's Day. That is correct. It is the 17th of March. And for all of those who have a birthday on this day, happy birthday to you. I have a few in my family. I'm sure a couple of people have some as well. So happy birthday to all the March babies. So I put my legalese in green. I got my Irish sweatshirt on. I'm wearing my green glasses and I have my green bow. So you cannot pinch me. I'm wearing my green. Well, law lovies. Oh my goodness. How are you doing? We had such a high these past couple of weeks, and then yesterday was just like nonstop high, right? First, you had the prosecutions closing in the Corey Richards case, and then call for a mistrial. Then you got the defense's argument, then a rebuttal, and you're like, I'll be done for the day. We're just gonna like take it easy because it was a long day. And you're like, I'm gonna focus on my family. I'm going to focus on dinner or whatever. No, wrong. Guess what? Here we go. Jury's coming back. There's a verdict. Now, mind you, I'm like, okay, that's great because then I can plan the rest of my week. But part of me is like, really? Like, really? And then so, you have like this high, and how are you going to come down from this high? So, anyways, it's all good. Eric Richins got the justice. Corey Richins, unfortunately, is going to get her comeuppance. Just tangled web we weave when we practice to deceive, and when you start to be dishonest with your spouse about money, and then you continue that with lying about perhaps the houses that you bought and what you're doing, and it's okay to have two separate bank accounts and what have you, but you got to be honest, right? If you're dishonest, it just leads to terrible things, and then affairs and stuff. It's just not good. And then money. But Sunday was the Oscars, and there were lots of famous couples on the red carpet, but we're going to check in with our famous couple, Shadow and Jackie. Here's Miss Jackie today on the 17th. She is looking really fabulous, right? She is on her nest, protecting those 2 baby eggs that she has. Latest reports from the Jackie and Shadow saga is that Jackie has been fiercely protecting her nest in the middle of the night. Some predators have been coming by, and at one point in time, she had a raven in her claws. So, somebody must have been messing around with her, and she didn't like it. There's also been reports that she's usually by herself protecting the nest in the night. Sometimes Shadow comes and he'll, sleep next to her. He brings her fish and stuff like that. And then they swap, they take turns. He will be in the nest while she goes out for a while. We still have a couple more weeks before we see any of the eggs hatch, but they're doing what they can, and some people are like, oh my goodness, like when they leave the eggs for unattended for a short period of time, like, oh no. So there's been some shenanigans going on, but people have been watching and observing just to see how these two are going to fare. And every year we go through the same thing, right? Every year we watch them, they lay their eggs, we watch them see if they're going to hatch anything. And last year, to recall, they had 3 eggs last year. They all hatched. The one baby just did not make it. They had 2 girls, and, as I said, parenting is difficult. One of their babies, just couldn't leave the nest, and they had to take extra parenting time to support that one, and I think that that one has come back to visit, uh, but I'm not 100% sure because you just never know, right? So, that is going on with Jackie and Shadow. If you want to know more information about it, it is the Friends of the Big Bear Valley. This is a cam high up in a some sort of a conifer tree, and that Jackie and Shadow have had this nest for several years now, and it's kind of fun to watch. There's another camera that goes and shows a wider view of their landscape. So sometimes in the background, you'll see there are other eagles flying around. You'll see other birds, etc. But this is their uh, reservoir, which with they get their food from. So it's kind of sometimes it's kind of fun to watch their their lives, right? It's like reality TV, but in Eagle Land. So, what are we going to talk about today? Well, it's been a while since we've had anything going on in the Karen Reed saga, right? Pretty much every month we still have something going on. The last time we had a couple of weeks ago, Mark Diller, who is the attorney for the O'Keefe family, had to apologize in open court for misstating statements that Karen Reed made. If you don't know who Karen Reed is, let me give you the smallest synopsis I can possibly give you. Karen Reed and her boyfriend, John O'Keefe, were at 2 bars the night of a blizzard happening in Canton, Massachusetts, which is just outside of Boston. They had gone to one bar and then they have gone to another bar. And at this second bar, they met up with some other people. Those people said, "Hey, why don't you continue the party with us?" It was like 12 a.m. Let's go to our house at 34 Fairview Road. John O'Keefe was a Boston police officer. Other people were in law enforcement, blah, 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 blah. Something happened to John O'Keefe. Karen Reed thought she dropped him off at 34 Fairview and she was upset and left. The next thing she knows, she wakes up at she's at his house because he lives in Canton. She wakes up, he's not there. She's called him several gazillion times throughout the night. She contacts 2 other people to see if they can help her go locate him. They find him, he is deceased on the lawn. What happened to John O'Keefe? Well, Karen Reed was tried twice. The Commonwealth of Massachusetts think that she hit him with her car. Although there is no damage to him, there's no damage to her car. Long story. First trial, there was a mistrial. Again, we talked about this in the Corey Richins case, that the reason why there was a mistrial, particularly, was that the uh, jury form with which they needed to, the verdict slipped, was very confusing. They thought it was an all or nothing because that's what the judge told them. So they thought, well, if we're not all agreed that these things happened, then therefore we don't mark anything. So there was lots of confusions. Even the jurors came out and said there was confusion and that they said that they didn't want to convict her and they did. But so mistrial, first trial. Then the Commonwealth was like, hold my beer. We're going to try you again. So they tried her again the second time. She was acquitted of all charges except for a DUI. That is where we left it off. Oh. Then the O'Keefe family, in the midst of the second trial, had filed a wrongful death suit against Karen Reed. And when I say the O'Keefe family, John O'Keefe's brother, Paul O'Keefe, and his parents, and one of his the niece of uh, John O'Keefe, they have filed a wrongful suit against Karen Reed. Karen Reed said, "Hold my beer, because I'm going to go ahead and I'm going to sue everybody else." So she sued all of the people that were inside the house at 34 Fairview because when she was arrested, they started claiming that she did it and they made these claims against her. So she's suing everybody that's in the house, a couple of law enforcement agencies, the town of Canton, and Massachusetts State Police. So, two lawsuits. The one against her from the O'Keefe family is in Plymouth Superior Court. That is regular court. The one that she's suing everyone has been moved to federal court. Which one are we talking about today? Well, lovies, let's bring it up and let us begin. And by the way, it is Saint Paddy, Paddy, for those of you. It is not Patty. All right. So, this is Karen Reed versus everybody. So this is the one that is in federal court. She has an amended complaint. What are we talking about? Well, we're going to get into it. So as you can see, Karen Reed is suing Michael Proctor. Michael Proctor was the lead investigator on her case. He is now former trooper Michael Proctor. He is no longer a trooper. Karen Reed. They found a whole bunch of stuff about him and that he was biased in her case. He got fired. Sergeant Yuri Buchnick, whatever. He's still a Massachusetts State Police officer. Lieutenant Brian Tully, he's still a Massachusetts State Police officer. The town of Canton, Brian Albert, Nicole Albert, they were the homeowners of 34 Fairview. They sold the house. Jennifer McCabe and Matt McCabe. Jennifer McCabe and Nicole Albert are sisters. And Brian Higgins, who was an ATF officer. All right, law lovies, we're going to go ahead and get into it. Here we go. For 3.5 years, plaintiff Karen Reed was wrongly accused of homicide and subjected to suspicion, arrest, 2 prosecutions, and public condemnation, all resulting from gross misconduct of the Massachusetts State Police and those working in tandem with MSP to shield from liability the party or parties responsible for the death of Boston police officer John O'Keefe. Did I mention John was a police officer? Brian Albert was a Boston police officer too. Now, after being acquitted of all charges relating to Mr. O'Keefe's death, Miss Reed brings this action to recover for and address the actions of those actually involved in Mr. O'Keefe's death and the law enforcement officers who objectively failed to ensure that justice was sought and served in the aftermath of January 29th, 2022. That is the day that they found John O'Keefe deceased on the lawn of Brian Albert's house. Karen Reed did not kill her then boyfriend, Mr. O'Keefe. Rather, in the early morning hours of January 29th, Mr. O'Keefe was killed in the defendants, Brian and Nicole Albert's home at 34 Fairview Road in Canton, the house, in an altercation during a late night house party with the defendants, collectively called the house defendants. After a night of heavy drinking, the house defendants responsible for Mr. O'Keefe's death, some of whom had professional experience with police investigations, concocted a plan immediately after the altercation to avoid culpability and to frame Karen Reed. Rather than call first responders for help, among other actions, the house defendants conducted a Google search for information about house long to die in the cold. If you don't know that phrase and you don't know what's happening, where have you been? It is alleged that Jennifer McCabe, it is her phone that search happened. She had opened up a tab on her phone. She was Googling something else at 2:30 in the morning that same morning. And when she opened up that tab, she claims at 6 a.m. at the behest of Karen Reed to state how long does it one die in the cold, that the tab that she opened was from 2:30 in the morning And it had that timestamp versus the 6 a.m. timestamp that she opened it. If you don't know what all of the brouhaha about that is, Karen Reed's camp says she opened it up at 2:30 a.m. The House defendants say nope, she opened it up at 6 a.m. Celebrite in the trials that Karen Reed had made a big to do about it and said, nope, there was an error in Celebrite, and therefore she did it at 6 a.m. And they even had to change their software because they said it was a software glitch. If you want to know more about that, you just go to YouTube and you type in Celebrite How's Long to Die, and you will see the love fest that was happening between two Celebrite people in reference to this conundrum. I don't know. All right. So, How's Long to Die in the Cold moved Mr. O'Keefe's body outside and placed him on the Albert's front lawn near the road to make it look like Mr. O'Keefe was hit by a vehicle and that he died in the snow without ever coming into the house that night. Mr. O'Keefe's body remained on the Albert's lawn until Karen Reed found him later that morning. From the beginning, investigators from MSB allowed the House defendants to direct the investigation away from themselves and towards Miss Reed. The House defendants were well connected and close social group with strong ties to law enforcement. The Alberts are a prominent family in Canton, and the investigating officers knew them well. The lead investigator for MSP, Michael Proctor, grew up in Canton, resides there to this day. He has been and remains close personal friends with the Albert family. House defendant Brian Albert was a longtime Boston police officer, and House defendant Brian Higgins was an agent with the Bureau of Alcohol and Tobacco, Firearms, and Explosives. Adhering to the unwritten rule of protecting their own, Proctor and his MSP colleagues intentionally disregarded the obvious, compelling evidence tying the House defendants to Mr. O'Keefe's murder. Specifically, Mr. O'Keefe's injuries were consistent with a physical alteration. So, when we said that there was no indication that he had been hit by a car, his eyes were puffy, his arms were bruised, and he had a cut on his face. Specifically, Mr. O'Keefe, not Mr. Reed, Mr. O'Keefe's injuries were consistent with a physical altercation. He had bruises and lacerations on his face, a deep gash in the back of his head, suggesting that he was punched and fell backwards, hitting his head on a ridged surface. He also had dog bite wounds and scratches on his right arm and forearm. Brian Albert and Nicole Albert owned a German Shepherd who was prone to attacking. She had two other altercations. Equally evident, Mr. O'Keefe did not have a single injury consistent with being struck by a vehicle. He did not have any broken bones or a bruise on his leg, feet, arms, shoulders, torso, back, ribs, or anywhere below his neck that a medical examiner would otherwise expect to find on a person struck and killed by an impact that a medical examiner would otherwise expect to find on a person struck and killed by an impact from a 3-ton vehicle. And to erase any doubt, the Commonwealth's own medical examiner, the pathologist who conducted the autopsy for the Commonwealth, concluded that Mr. O'Keefe's body showed no signs of a vehicular strike. Despite that, Proctor and others shielded the House defendants by intentionally sidestepping fundamental investigatory procedures. Propelled by the House defendants' false statements, including that Mr. O'Keefe never went into the house, that was in a text. Proctor reported in text messages just hours into the investigation that the House defendants weren't going to get any shit for this because he, Brian Albert, is a Boston cop. And that Proctor was determined to make the investigation cut and dry by bringing charges against the girl. Indeed, Proctor made his intentions clear in writing. Karen Reed has zero chance of skating. She's fucked. The pronouncement was a mere 16 hours after Mr. O'Keefe's body was discovered on the Alberts lawn, and Proctor had not even walked to the house. let alone investigated inside the house. True to his promise, Proctor and his colleagues did not search the house for blood evidence resulting from the gash on the back of Mr. O'Keefe's head, or for fingerprints, or for DNA evidence. Proctor did not search the house, he did not search the house, he did not search anywhere. Proctor did not search the house, not even with a mouse. Despite the fact that Mr. O'Keefe was discovered without a winter coat, without the hat that several witnesses said he had been wearing that night, and without his left shoe. They later recovered that, the CERT team did. At Proctor's direction, the house was never processed by a criminalist or even photographed. No member of the MSB, including Proctor, set foot in 34 Fairview for nearly a week. The police did not examine or take evidence from the Alberts German Shepherd that was in the house on January 29th, a dog that had a history of attacking other dogs and people. Neither Proctor nor any of the MSP troopers conducted physical examinations of the house defendants for evidence of involvement in the altercation, such as marks on their hands, knuckles, or face, or bruises on their bodies. They did not seize or search the house defendants' phones, except that which belonged to Jennifer McCabe, who turned her phone over only after making setting changes on the phone February 2nd, 2022. She also deleted some of her messages. And in Corey Richens' case, when they said she deleted her messages, that was consciousness of guilt. They conducted only a pre-functionary, unrecorded conversations with Proctor's friends and acquaintances without any attempt to corroborate their stories. Corroborate. They permitted would-be witnesses to communicate with each other and coordinate their stories before any formal interviews. The following morning, Jen McCabe and a lot of other house defendants got together and made a timeline. They allowed critical evidence to be manipulated in some instances and outright destroyed in others. In short, by focusing the investigation solely on Miss Reed, as implicitly directed by the House defendants through the misrepresentations they made to police. Proctor and his colleagues disregarded and failed to obtain pertinent interviews and other critical evidence from the House defendants that cannot now be recovered or recreated. Proctor also secretly communicated with the Alberts on his personal phone, deliberately back-channeling those communications to circumvent his state-issued device. Ooh, and used his sister as a conduit. So, how do we know this? So Proctor had a phone issued from Canton PD that was his work phone. He also used his personal phone, and he would contact his sister, who was friends with these other people, to be sort of a back channel. But they did get some of his personal messages off of his phone for the first, was it first trial? Yes, the first trial in Karen Reed's. And that's how they found out that he had made these text messages with his buddies, etc. Well, then Proctor got a new phone, and he's like, I got a new phone, so good luck. And they're like, hold my beer, because guess what? We got you. And how do we got you? We got you because the cloud. So there are 10,000 plus messages on Proctor's new phone that he said, I don't have anything on there, and I'm wondering if this is part of it. So, to circumvent his state-issued device, his phone, he used his sister as a conduit. For instance, on multiple occasions, Proctor disclosed critical and confidential information about the investigation to his sister, who passed that information on to her close friend, Julie Albert, Brian Albert's sister-in-law. Julie Albert then passed the same information on to the rest of the family and the House defendants. Part of these communications included Julie Albert's promise to buy Proctor a thank you gift for handling this investigation in a manner that intentionally avoided implicating the House defendants, and singularly focused on Miss Reed. Proctor then went as far as to manufacture evidence to ensure that Miss Reed, not his friends and fellow law enforcement officers, was blamed for Mr. O'Keefe's death. This included planting evidence at the scene on Mr. O'Keefe's clothes and Miss Reed's vehicle to support the false narrative that Miss Reed hit Mr. O'Keefe with her car, even though he knew Mr. O'Keefe's injuries were inconsistent with a motor vehicle strike and consistent with a physical altercation and dog attack. Far from conducting an objective investigation with integrity, Proctor personally sexualized and dehumanized Miss Reed throughout the investigation. Specifically, Proctor's private communications to his high school buddies, sister, and MSP colleagues that he believed would never be discovered exposed the corruption and bias at the core of MSP's entire investigation. Specifically, only hours into the investigation, in a text chain with 8 of his high school buddies, Proctor stated that Miss Reed was a whack job, see you next Tuesday, retarded and nutbag, and a babe with no ass. Proctor further ridiculed and derided Miss Reed for her serious medical condition, stating that her balloon knot leaked poo. In other private text messages to his MSP supervisors and colleagues, Proctor bragged that while conducting a search of Miss Reed's phone, he was looking for naked pictures of Miss Reed. No nudes so far. Disappointed, he reported that there were no nudes so far. I should just continue reading. In an unfiltered utterance, Proctor revealed his true mindset. Hopefully, she unalives herself. These things that are in quotation marks are things that Proctor actually texted. Indeed, Proctor's supervisors and the MSP knew about and condoned Proctor's unlawful conduct. In some instances, expressly encouraged this flagrant abuse of power. For example, one occasion, Proctor's immediate supervisor, Yuri Buchanan, responded with a thumbs up emoji to a text calling Miss Reed retarded. Proctor's supervisors and the MSP knew Proctor had a close relationship with the Alberts and that he made no secret of his bias against Miss Reed, demonstrating a clear prejudice against her from the outset. Relying on manufactured evidence and actively ignoring exculpatory evidence and without investigating obvious signs pointing towards the House defendants, the Commonwealth secured 2 separate arrest warrants for Miss Reed and a knowingly baseless indictment against her, and then wrongfully prosecuted her for murder twice. As alleged below, these unlawful acts not only read the words. As alleged below, these unlawful acts not only underlie plaintiffs' meritless wrongful death claims against Miss Reed, but they also form the foundation for Miss Reed's claims against the defendants. These acts violated Miss Reed's state and federal constitutional rights, the Massachusetts Civil Rights Acts, as well as established Massachusetts tort principles. On June 18, 2025, after a 2-month trial, a jury rejected the Commonwealth's theory in part because the overwhelming physical, scientific, and medical evidence established that Miss Reed's vehicle did not strike Mr. O'Keefe, and that Mr. O'Keefe's injuries did not come from a vehicle strike. Although Miss Reed was ultimately and finally acquitted of all charges related to the death of Mr. O'Keefe, Proctor was fired, and nearly every MSP officer in Proctor's chain of command was disciplined for their egregious abuses and misdeeds. The Commonwealth still has not sought or provided justice, not to the O'Keefe family, not to the community at large, and certainly not to Miss Reed. In response, the Commonwealth has offered only empty platitudes instead of solutions. The head of MSP, Colonel Jeffrey Noble, stated, "The events of the last 3 years have challenged our department to thoroughly review our actions and take concrete steps to deliver advanced investigative training, ensure appropriate oversight, and enhance accountability." Boilerplate, boilerplate, boilerplate. Under my direction as Colonel, the state police has and will continue to improve in this regards. In an interview with the Boston Herald, Noble acknowledged the systematic nature of MSP's conduct in Miss Reed's case. I'm eyes wide open to the cultural issue that I have concerns with as it relates to Trooper Proctor. These hollow words do nothing to right the devastating wrongs that have been visited on Miss Reed. Colonel Noble's words confess a sickness deep in the marrow of MSP, but offer no remedy, no medicine, no relief to someone who's so brutally victimized by it. On March 19th, 2025, following the public disclosure of Proctor's illegal and unethical conduct related to the Reed investigation, the MSP's trial board found Michael Proctor guilty of a Class A violation, which included that he was biased in his dealings with a homicide suspect and or brought otherwise himself and Massachusetts State Police into disrepute. Miss Reed's life was not merely turned upside down by MSP and the House defendant's misconduct. It was forever changed by the defendant's transgressions and wrongdoings. The years of uncertainty and unimaginable emotional distress have left lasting scars that will never heal. At the same time, neither Mr. O'Keefe nor his family has received justice. His killer or killers still walk free. By asserting her claims against MSP, Proctor and his supervisors, the town of Canton, and the House defendants, Ms. Reed seeks, at a minimum, to confront and redress those wrongs and others. More importantly, she seeks the force of the Commonwealth to fulfill its duty to stop law enforcement from trampling the innocent to protect their own. Bum, ba-dum, bum, bum. The parties. And it's not like a party that you want to go to. Plaintiff Karen Reed, defendant Michael Proctor, defendant Sergeant Yuri Buchanan, Lieutenant Brian Tully, Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, Brian Higgins. We know the jurisdiction. Facts common to all counts. Before his death, Mr. O'Keefe and Miss Reed were dating. On the evening of January 28th, 2022, Mr. O'Keefe and Miss Reed went out for the night. They first went to see if McCarthy's in Canton, where they had several drinks. Then they went to the Waterfall Bar in Canton. There they met up with a group of acquaintances, including Brian Albert, his wife, Nicole Albert, Brian's brother, Chris Albert, his wife, Julie, Jennifer McCabe, Nicole's sister, and Brian's sister-in-law, her husband, Matthew McCabe, Brian Higgins. The group of acquaintances had several drinks and planned to continue their party back at the Alberts' home at 34 Fairview in Canton. House defendant Jennifer McCabe told John O'Keefe that they should come to the house. The group had overlapping social relationships. At the time, Brian Albert was a Boston police officer, as was Mr. O'Keefe, though they did not know each other very well. Brian Albert and Brian Higgins were close friends. Higgins resided in Canton for many years through January 2022 and was an officer with the ATF. He was also permitted to keep an office at the Canton Police Department alongside Brian Albert's brother, Canton Police Detective Kevin Albert. Kevin Albert had a professional and social relationship with Michael Proctor, as well as Brian Higgins. Higgins had been on a trip with both Brian and Kevin Albert in the days preceding January 29th, 2022. They had traveled to New York to go to a fellow officer who had been deceased to their funeral and drinking most of the day. Brian and Nicole Albert's son, Brian Albert Jr., and his friends were already at the house for Brian Jr.'s party. In addition, Colin Albert, Brian Albert's nephew, was present. Miss Reed and Mr. O'Keefe had never been to the house before January 29th, 2022. They arrived in front of the Alberts' home at 12:20 a.m. Miss Reed was reluctant to attend the party for several reasons, including which she was unsure whether they were even at the correct location and whether they were even welcome into the late-night party. Mr. O'Keefe got out of Miss Reed's SUV and indicated that he would check out the party and report back to her. Mr. O'Keefe walked to the front door, garage door area of the house. entered one of the two doors. According to the O'Keefe's Apple Health data, his final steps covered just enough distance to get from the foot of the driveway into the house or garage. A period of time passed without any word from Mr. O'Keefe. Miss Reed, who was still hesitant to join, presumed that Mr. O'Keefe intended to stay, and therefore she left to go home without him, and left him many voicemails stating how upset that she was at him for going in without her. At some point entering the house garage, Mr. O'Keefe was involved in a physical altercation, either inside the house or garage. During that altercation, hang on just a second, I'm going to move my mic. All right. At some point after entering the house garage, Mr. O'Keefe was involved in a physical altercation, either inside the house or garage. During that altercation, the Albert's German Shepherd attacked him, and Mr. O'Keefe sustained multiple dog bites, scratches on his right arm. He also suffered an incapacitating counter-coup wound on the back of his head. Mr. O'Keefe's head wound was caused by falling backwards and striking a ridged surface. The Albert's garage contains such surfaces, plural. By contrast, the head wound could not have been caused by a vehicle strike or falling back onto a flat, cold lawn, like the Albert, because that's where he was found. He was found on the lawn of the Albert home. Because of their knowledge of criminal investigation, the Alberts and McCabe's Higgins house defendants knew that they were calling for a medical care but help save John O'Keefe's life would trigger immediate and irreversible risk of their own criminal exposure. Therefore, at least 5 of them agreed on a simple plan to exonerate themselves and implicate Miss Reed. They would tell anyone who inquired that Mr. O'Keefe never entered the house and hide evidence that he was there, including his body. Sometime during the night, they repositioned a Ford Edge vehicle at a spot adjacent to the front lawn, which obscured the view and of that area of the front lawn from potential passerbys. At some point further in the night, they carried or dragged Mr. O'Keefe's body to the same area in the yard, close to where one or more of them later claimed Miss Reed dropped off Mr. O'Keefe earlier that night. The plan was devised to make it appear that Mr. O'Keefe had been struck by Miss Reed's vehicle and then died as a result of the exposure to the cold. Mr. O'Keefe was either dead when the house defendants left him on the Albert lawn, or he died shortly thereafter. After the physical altercation, Higgins left the house and drove to Canton Police Department in the middle of the night. He later told investigators that he had to do some administrative work, but then changed his story, subsequently stating that he drove to the station because he had to move cars in the parking lot due to the snowstorm, even though he could have done that earlier in the evening when he was at the station to drop off Kevin Albert. However, video from inside the station shows Higgins walking down the hallway and surreptitiously, surreptitiously, let's say that 5 times fast, entering offices wearing a black hoodie to obscure his face. Surveillance video outside reveals Higgins transporting a large bag on one vehicle to another before driving away. After leaving the police station, Higgins and Brian Albert continued to coordinate their stories by calling each other multiple times in the early morning hours, butt dialing, and ultimately spoke with each other on their cell phones at 2:22 a.m. Later, both Brian Albert and Higgins denied the existence of these phone calls, and when confronted with their existence by a separate law enforcement agency, a non-MSP and non-CPD law enforcement agency, at a separate proceeding, FBI coordinated the exact lie, falsely claiming that multiple calls, answers, and hung-ups were just butt dials. However, 5 minutes after Higgins and Albert's call, Miss McKay performed the Google search on her phone at 2:27 a.m. How's long to die in the cold? Misspelling the first word. Miss Reed searches for Mr. O'Keefe. Miss Reed began the search for Mr. O'Keefe on January 29th, just before 5 a.m., when she awoke and realized that he had not returned home. She phoned House Defendant Jennifer McCabe, who had already knew exactly what had happened to Mr. O'Keefe. Miss McCabe insisted that Miss Reed drive to Miss McCabe's house rather than to 34 Fairview Road, in which Miss Reed did. At the exact same minute, Miss Reed left Mr. O'Keefe's home at 5:07 a.m. Miss McCabe made a 38-second phone call to her sister Nicole Albert at 34 Fairview. Nicole Albert said she was asleep until after 6 a.m. And Jennifer McCabe, when confronted with the call artifact at trial, claimed not to have any knowledge of the call. Miss Reed and Miss McCabe were then joined by Carrie Roberts, and the three of them left the McCabe's residence. However, rather than go to 34 Fairview, oddly, Miss McCabe directed them to go back to Mr. O'Keefe's home, where Miss Reed had just come from. After the three of them finally drove to 34 Fairview, the illogical McCabe directed route to 34 Fairview was intentional. It allowed House defendants more time to finish creating the scene and hiding evidence before Mr. O'Keefe's body was discovered on the Alberts lawn and first responders arrived. As they approached the house with Miss Roberts driving, Miss Reed saw Mr. O'Keefe almost immediately. She screamed for Roberts to stop the vehicle and jumped from the moving car and ran to Mr. O'Keefe. She began rendering aid, including CPR. As the House defendants had planned, Mr. O'Keefe's body was discovered in the front of the Alberts house near the flagpole and fire hydrant on the left side of the Alberts property, as seen from the roadside. The Ford Edge, which had been parked in a position to obscure Mr. O'Keefe's body in the middle of the night, had been moved. While Roberts joined Miss Reed with administrating CPR, Miss McCabe did not help or even approach Mr. O'Keefe. Rather, she sat on the cab of the vehicle and called 911 and reported that there's a man passed out in the snow. There's a man passed out in the snow. Despite knowing that her brother in law, Brian Albert, a police officer and first responder, was just feet inside the house, Miss McCabe never went into the house or requested that Albert come down to help Mr. O'Keefe. Rather, as Mr. O'Keefe was lay there dying in the snow, Miss McCabe stood and watched with no fear, urgency, or even concern for her family members residing mere feet away. We can tell that Mr. Uh, Alan Jackson had wrote this because he had stated this in open court. The CPD were the first on the scene shortly after 6 a.m. At the time, there's no evidence that Mr. O'Keefe's body had been hit by a vehicle. In fact, the evidence suggested just the opposite. His body did not show signs of trauma commonly associated with being struck by a car. There were no bone fractures or trauma to his lower body, torso, or any part of his body, as investigators would expect from a vehicle strike. Rather, Mr. O'Keefe's injuries were consistent with being physically assaulted to the face, head, and attacked by a dog. For good reason, the ranking CPD officer at the scene, Sergeant Michael Lank, opined on a telephone call to MSP Homicide, captured on dashcam audio, that Mr. O'Keefe looked like he'd been in a fight. Moreover, the initial search conducted by Canton police officers revealed that there were no vehicle debris on the lawn at 34 Fairview, let alone any debris at or near Mr. O'Keefe's body. Not a single piece of taillight material was discovered on the lawn or in the roadways that morning, notwithstanding multiple searches and the use of a leaf blower to remove snow. Tellingly, despite the commotion outside, including more than a dozen first responders, three police cruisers, two ambulances, a ladder fire engine, all with their emergency lights flashing, and at least two civilian vehicles, plus Miss Reed's screams upon finding Mr. O'Keefe's body, no one from the Alberts home, including police officer Brian Albert, ever went outside to see what was happening, let alone help. They wanted to avoid scrutiny from the police investigators. Sergeant Lank was a longtime friend of the Alberts and first law enforcement officer to enter the house. He spoke with the Alberts and the McCabes. Pursuant to their plan, the Alberts and the McCabes told Sergeant Lank that Mr. O'Keefe had never entered the Alberts home. The Alberts and the McCabe's statements were false. Mr. O'Keefe arrived at and entered the house or garage where he was assaulted, attacked by the Alberts' dog, and suffered a fatal injury to the back of his head. Okay, we buffered their consistent with the story like and whether they request to search the occupant's cell phones, observe their bodies for evidence of a fight, or even secure the scene where Mr. O'Keefe's body was found. They failed to do so on a bias born of friendship and loyalty in favor of the Alberts and McCabe's. After Sergeant Link returned to the CPD 3 hours after his discovery of Mr. O'Keefe's body, more than 2 hours after being interviewed at the Alberts home that morning, Jennifer McCabe called Sergeant Link to report that she recalled additional information. Except for this one call to Sergeant Lake, Miss McCabe deleted from her phone evidence of all other phone calls she made and received January 28th to just before 9 a.m. on January 29th. As part of the plan to implicate Miss Reed and remove suspicion from the House defendants, she falsely told Sergeant Lake that Miss Reed told her twice that morning, "I hope I didn't hit him." More than a year later, at a separate proceeding, McCabe changed her story on this topic yet again. In furtherance of the House defendant's plan, McCabe then falsely reported that Miss Reed outright confessed to hitting Mr. O'Keefe right after she had first found him in the snow. By the way, this is 54 pages. We're only on 14. Let's pause here for just a moment. All right. StreamYard is giving me a hard time, so we had to reboot. Here we are. Proctor leads MSP investigation despite conflicts. Michael Proctor was assigned as the case officer and had primary responsibility for the MSP investigation of Mr. O'Keefe's death. Sergeant Yuri Buchanan was Proctor's direct supervisor. Lieutenant Brian Tully was a supervisory officer at the Norfolk State. Brian, Brian Tully was the supervisory officer at the Norfolk County State Police Detective Unit and thus supervised both Buchanan and Proctor. In both roles, Buchanan and Tully both knew at all times the exact extent of Proctor's misconduct in investigating Mr. O'Keefe's death, as described below. From the beginning, Proctor should have never been assigned as an investigating officer, let alone a lead investigator. He grew up and resides in Canton as a good friend of the Alberts and had known the family for years. Proctor and Julie Albert, Brian Albert's sister in law, had each other's personal cell phone numbers. In fact, just days before Mr. O'Keefe's death, Proctor communicated with Julie Albert about babysitting Proctor's minor child. Proctor's sister, Courtney, was also a close friend of Julie and lived walking distance to the Alberts' home at 34 Fairview. In fact, Proctor's own mother referred to the Alberts as Proctor's second family. The existence of these relationships was intentionally suppressed by Proctor and other members of MSP, including Buchanan and Tully, in an effort to ensure the House defendants were protected and that Miss Reed's right to a fair investigation and trial were undermined. Proctor, Buchanan, and Tully engage in a corrupt and biased investigation by not investigating inside the House, interviewing the House defendants as friends rather than suspects. Proctor, Buchanan, Tully, and MSP never searched for DNA evidence inside the house, never looked for ridge surfaces that could have caused the gash on the back of Mr. O'Keefe's head, never inspected the house defendant's body for indication of bruises or cuts that resulted from an altercation, and did not search the house defendant's cell phones with the exception of Jennifer McCabe. This allowed potential evidence to be destroyed, disposed of, removed, or simply become unrecoverable. Proctor, Buchanan, and Tully's interviews of the House defendants were also outside of the normal protocol. They were all interviewed either at their home, their family member's home, their lawyer's home, and in case of Brian Higgins, their lawyer's office, and in the case of Brian Jr. and Caitlin Albert, their place of employment, or over the phone. These interviews were each untimely, unrecorded, and fundamentally designed to protect the House defendants. And the House defendants took full advantage of it. Specifically, Jennifer McCabe became the point person for the House defendants in providing their false narrative to investigators and continued to serve the role for years. He managed and communicated details about the House defendants, messaging, and the investigation itself, including visiting Proctor and other investigators' private residences, mapping out timelines to coordinate statements with other witnesses, leading group message chains that were later partially deleted, and planning private meetings at all hours of the night and day. Indeed, these were never the acts of innocent witnesses seeking to help an investigation concerning the death of an alleged friend. Rather, they were predicated acts of a conspiracy among a group of people with shared goal of deflecting their criminal exposure onto someone else. McCabe was wildly active on her phone in the immediate aftermath of the house altercation that killed Mr. O'Keefe. Her cellular data reveals that she arrived back at her home at 12 Country Lane at 2:12:38 a.m. on January 29th. Her phone unlocked at 2:23 a.m. and at 2:31 a.m. Text messages were sent between 2:25 and 2:25 a.m. Two screenshots were deleted. Her Apple Health recorded steps throughout the night after she arrived home at 2:14, 2:15, 2:16, 2:17, 2:18. Okay, I'm not going to go through each one of these. You can read for yourself. An outgoing call to Nicole Albert at 5:07 a.m. The last cellular artifact is particularly revealing because McCabe's call to her sister occurred 1 hour before John O'Keefe's body was discovered, mere moments after a 43-second call at 5:05 a.m., during which Reed and McCabe agreed to go searching for O'Keefe's ring video from One Meadows, showing Reed leaving the property at exactly 5:07 a.m. McCabe's coordination continued on February 1st when she worked with other witnesses, Carrie Roberts, to draft a timeline in order to align their stories regarding what had occurred on January 29th. They did this in preparation for Roberts' interview with MSP, which occurred at the McCabe's residence despite MSP's protocol to separate witnesses when interviewed. Sorry, it says to separate witnesses. She was in the other room. She's telling them everything. Oh, I should just keep reading. Oh my goodness, I kid you not. Oh, I should just stop. All right. While MSP interviewed Miss Roberts, McCabe simultaneously texted her husband, Matthew, Nicole Albert, and Brian Albert, saying she's telling them everything, all the stuff. Nicole Albert responded, "Good, and call us after." 2 months later, after being prodded and influenced by McCabe and other House defendants, Roberts changed part of her story to better fit with Jennifer McCabe's own false statements. Specifically, Roberts testified falsely in a grand jury proceeding on April 26th that she heard Miss Reed ask Miss McCabe to Google hypothermia. She had not made this claim in any of the at least 3 interviews she gave MSP investigators in the days after Mr. O'Keefe's death, in part because it never happened. Carrie's new and false story to the state grand jury aligned exactly with McCabe's testimony that Miss Reed asked her to Google hypothermia. Roberts even adapted McCabe's false claim that Miss Reed had supposedly asked the question while praying in a CPD cruiser outside of 34 Fairview. Later, Roberts conceded that she never heard Miss Reed ask Mr. McCabe to Google anything. She admitted this a year later in a separate proceeding on April 19th, conducted by a different law enforcement authority, not Proctor and MSP, the FBI. Again during Reed's criminal retrial in 2025. The House defendants deleted many of their texts, among others in the aftermath of O'Keefe's death. Texts captured between deletion and recovery later also revealed some of the House defendants' planning. For instance, on the evening of the 29th, Jennifer McCabe texted with her sister Nicole that Carrie Roberts, who was present when Mr. O'Keefe's body was found, talk to the cops and keep it simple. Of course, there would be no reason to report back to other House defendants about Roberts keeping it simple unless it really unless what really happened was more complicated. Proctor, Buchanan, and MSP never sought these communications. Rather, they were obtained by Miss Reed's defense attorneys' repeated motions to compel access to data on Jennifer McCabe's iPhone. Later, another group texts the with Jennifer McCabe and Brian and Nicole Albert. Matthew McCabe suggested having Chris Albert publicize their crafty story to a reporter, asking Chris to ask some questions. Tell them that the guy never went into the house. As an endorsement of the plan, Brian Albert responded, exactly. Importantly, the text messages from the House defendants' phones that were ultimately recovered and that provided a window into their conspiracy and misconduct, as well as MSP's unlawful investigation, were not the product of CPD or MSP investigative work, rather based on media reports raising serious questions about MSP's investigation and the House defendants' role in Mr. O'Keefe's death. Another separate law enforcement agency, began its own subsequent investigation. That investigation, and not MSP's, resulted in obtaining some of the House defendants' phones, taking statements from House defendants, and conducting a separate proceeding, all of which MSP refused to do itself. Indeed, the evidence procured by the separate law enforcement agency, the FBI, investigation demonstrates the House defendants' conspiracy and unlawful conduct, as well as MSP's bias and corruption. Proctor and Buchanan initially interviewed the McCabe's and Brian Albert on January 29th and the McCabe's home at 12 Country Lane, at which time they stated that Mr. O'Keefe never entered the Albert's home. However, Jennifer McCabe's cell phone location data shows that she was at 34 Fairview all morning, leaving at 11:15 a.m. just to meet Proctor at 12 County Lane at 11:30 a.m. According to Proctor, he was at CPD just a mile from 34 Fairview before proceeding to the McCabe's home for their second scheduled interview. At that point, Proctor had still not inspected 34 Fairview. He had not interviewed either the McCabe's or the Alberts. He could have done simply by driving a mile to 34 Fairview, where the McCabe's and the Alberts were minutes earlier, rather than drive across town minutes later in a snowstorm. He did this intentionally to avoid 34 Fairview, where he would have been required to inspect the house and property and make reportable observations. He also wanted to make the McCabe's and Alberts more comfortable for their interviews. Buchanan and Proctor did not interview Nicole Albert, Brian Higgins until February 3rd, did not interview Chris and Julie Albert until February 10th, nearly 2 weeks after Mr. O'Keefe's death and more than a week after Miss Reed was arrested and charged, and did not interview Caitlin Albert and Brian Albert until September 15th, nearly 2 years later, 2023. Before both interviews, the McCabe's and Alberts continued to coordinate their stories as evidence in group text chats, same thing. Proctor, Buchanan, and Tully likewise failed to conduct a meaningful investigation into Higgins' involvement. When Proctor Buchanan interviewed Higgins on February 3rd at Higgins' attorney's home in Sharon, Massachusetts, Higgins presented the troopers with a select set of self-curated texts between himself and Miss Reed. They learned that Higgins and Miss Reed had been exchanging flirtatious texts, and that Higgins reported at least one instance in which Miss Reed and Higgins had kissed while at Mr. O'Keefe's house, mere weeks before his death. Rather than pursuing Higgins as a possible suspect, gotta take a quick drink here. Proctor, Buchanan, and Tully refused to investigate the matter further. They never interviewed Higgins again, even after surveillance video revealed Higgins was suspiciously hiding his face in the halls and parking lot of CPD at 1:30 a.m. and on January 29th. The video contradicts Higgins' statements about his actions that night. However, not only did Proctor, Buchanan, Tully, and MSP not investigate what Higgins was what Higgins was doing, or what was in the bag that he was carrying in the videos, but they went so as far as to hide the video from Miss Reed and her criminal defense attorney for years. That's right. This lovely video was not discovered until trial number 2. Late, late, late. Miss Miss Reed's defense did not receive these videos until after she stood trial for the first time. Is that a Brady violation? You tell me. And even after separate law enforcement agencies' investigation revealed late-night phone calls between Brian Albert and Brian Higgins, MSP failed to pursue either witnesses further or seek a full forensic extraction of Higgins' phone and even a simple call log from his cellular provider. This concerted inaction by MSP by Proctor, Buchanan, and Tully directed benefited the House defendants, especially Higgins and Brian Albert, who proceeded to dispose of and destroy their phones just for the criminal court order for them preserved in response to a motion by Reed's criminal defense. That's right, just before a preservation order was to be given on Higgins and Brian Albert's phone, they were magically destroyed or replaced. Specifically, on the 15th of September of 2022, Ms. Reed's defense attorneys filed a motion requesting that the court order Brian Albert and Higgins to preserve the contents of their phones. A Superior Court judge held a hearing on that motion on September 22 and announced in open court that the defendants were required to preserve their phones, signing a preservation letter to that effect on September 23rd. Higgins was served with a copy of the court's order on September 30th. He later testified that he changed phones and mobile carriers on September 29th. Later on October 2022, Higgins then destroyed his old phone, which was subject to the court's preservation letter. In fact, Higgins went so far as to drive to a military base on Cape Cod, remove the SIM card from the phone, and cut the SIM card with scissors he brought with him to destroy and dispose of the phone and card in two separate dumpsters before driving back home. How do we know this? Well, he admitted to doing so. That's right, he admitted to destroying evidence. Is that a crime? He is an ATF officer. Brian Albert received a copy of the preservation letter sometime between the 23rd and 24th of September. He originally testified that he threw his phone away in the third week of September of 2022, but then later claimed that he did so on September 22nd, one day before being notified of the court's order, and the same day Miss Reed's defense attorneys argued in open court that the phone should be preserved. Why? Why are you destroying your phones? You have nothing to hide. Higgins and Albert's destruction of their phones eliminated potentially incriminating communications between them and was a direct result of Proctor, Buchanan's, and Tully's intentional refusal to collect important investigative evidence that would be exculpatory to Miss Reed. Even after learning about the destruction of both witnesses' cell phones, MSP investigators had other avenues they could have used to pursue evidence, such as cellular toll records or simply interviewing Higgins and Albert to inquire about the nature of their late night communications. They intentionally ignored these avenues as well. Not only did Proctor fail to probe his friend's stories, he coordinated with them through his sister, and Proctor spoke to Courtney multiple times a day, knew she was in close contact with and providing information to Julie Albert. Julie and Courtney called each other many times between February 1st, 2nd, and at least 6 to 7 times between February 1st and September 6th of 2022. For example, as he prepared to question Chris and Julie Albert on February 10th, Proctor told his sister Courtney that the interview was not a big deal. Courtney told Proctor that Julie Albert had been nervous and wanted to give him a thank you gift after the interview. To avoid scrutiny, Proctor instructed Courtney to tell Julie to give the gift to his wife Elizabeth Proctor. Proctor shared investigatory details with Courtney before they were public. In the same instance referenced above, when his sister informed him that Julie Albert had been so nervous before the interview, instead of investigating further, he shrugged it off, laughed, and asked, "Why?" But Proctor knew exactly why Julie Albert was nervous. He sought to reassure her by telling Courtney that it was fine, just a quick convo. And then after the interview, Proctor spoke to Julie on his personal cell phone in an unreported conversation. Proctor never treated the Alberts as witnesses in a murder investigation. He protected them and treated them like family, friends that they were. At one point leading up to some of the interviews, Jennifer McCabe asked Nicole Albert if she had heard anything more about the investigation, confident she would learn more from Julie Albert again. Through Courtney, Nicole Albert responded, "We'll get more information tomorrow. Don't want to text about it." House defendants did not want to text about their activities and communications because they tried to hide or lie about them. Oh boy. For instance, it was discovered on the second criminal trial that Jennifer McCabe had lied in her sworn testimony in front of the first trial about not visiting 34 Fairview with Carrie Roberts on January 30th on their way to Sergeant Lank's house. However, while they did not text about this meeting, McCabe's cell phone location data obtained later by Miss Reed's defense reveals that she did, in fact, visit 34 Fairview just one day after O'Keefe's death and lied about it. Again, the cellular evidence and the deception by McCabe was never investigated further by the MSP, despite the fact that they had Miss McCabe's full phone extraction since February 2022. The McCabe's, Alberts, Higgins all told similar false stories to investigators in their interviews, and Proctor Buchanan Tully accepted their coordinated statements without making efforts to corroborate their stories. For example, Higgins testified before the state grand jury on 28th of 2022 that he parked his Jeep Wrangler in front of 34 Fairview with the duration of his stay on January 29th. However, none of the other House defendants or percipient witnesses who parked briefly out front of 20 at around 2:30 a.m. Ryan Nagel, Heather Maxon, and I'm going to mispronounce this, Deontonu, ever testified about seeing any other vehicle parked there other than Miss Reed's Lexus. Matthew McCabe claims that he had seen a V-shaped tire tracks in the snow, another observation not corroborated by any other witnesses. Further, Brian, Nicole, and Albert, I just messed that up. Further, Brian and Nicole Albert initially told Sergeant Lank of CPD that their daughter, Caitlin Albert, left the house that night around 12:15 a.m. when she was picked up by her boyfriend. However, when Caitlin Albert and Brian Albert Jr. were interviewed August 2023, they both testified that Caitlin was the last person to leave 34 Fairview that night at approximately 1:45 a.m. Brian and Nicole Albert clearly made efforts to exclude placing their eldest daughter at the house when Mr. O'Keefe was there. Neither Proctor, Buchanan, Tully, Link, MSP, or CPD ever further investigated this 90-minute discrepancy regarding the presence of a key witness to an alleged unaliving. Instead of taking the routine, objective, and necessary steps to investigating the McCabe's, Higgins, and Alberts, Proctor, Buchanan, Tully focused exclusively on Miss Reed as a suspect from the start of the investigation, despite substantial evidence exonerating her and implicating others, just as the House defendants intended. Proctor seized Miss Reed's cell phone and her SUV within 30 minutes of interviewing her on the 29th. He arrested her 72 hours later before reviewing any surveillance from the bars or ring camera footage, before interviewing exculpatory witnesses, and before the medical examiner's official conclusion that the manner of death could not be determined. and that there were no injuries to Mr. O'Keefe's body consistent with a vehicle strike. Much to Proctor's surprise, through the separate law enforcement agency, the FBI, investigation, his contemporaneous text messages were discovered. Among them, Proctor texted with his high school friends on the evening of January 29th, the day he began his investigation. He told them that the MSP had already determined that the Alberts were not going to receive any scrutiny about Mr. O'Keefe's death, even though the MSP had not at that point visited the crime scene or had been inside the Alberts' home and had performed only a cursory interview of the McCabe's and Brian Albert. Proctor told his friends that Mr. O'Keefe had been hit by a car and had not been in a fight, despite the fact that Mr. O'Keefe had suffered no injuries consistent with a vehicle strike. But he did have injuries consistent with a fight or a dog attack. Proctor rejected a friend's belief that Brian Albert, the homeowner of the property Mr. O'Keefe's body was found, would receive some shit. Instead, agreeing with another friend's presumption that you guys, the MSP, are out to make it cut and dry since it involves cops. Proctor revealed that he had already decided he was going to put serious charges on Miss Reed and that she was fucked, and that there was zero chance she escapes. From the outset, Proctor was determined to pin it on the girl. Proctor's supervisors were aware of his bias and conflicted relationships in the investigation. They didn't have to guess. Proctor told them. He told them he knew the Alberts' text messages from Proctor to Buchanan and other MSP troopers show Proctor had decided to focus suspicion on Miss Reed to the exclusion of everyone else. He had told the troopers that Miss Reed was retarded and that he was searching her phone for nudes of her. In the text chain, Sergeant Buchanan liked Proctor's text describing Miss Reed as retarded. Buchanan received Proctor's text and never reprimanded Proctor or addressed his improper bias and conduct. Because he was determined to put serious charges on Miss Reed, Proctor ignored the fact that the Commonwealth's medical examiner could not conclude that Mr. O'Keefe's death was a homicide, determining instead that the manner of his death could not be determined. The medical examiner also refused to conclude that Mr. O'Keefe died as a result of being struck by a vehicle, and later testified at trial that his injuries were not consistent with a car strike. Proctor later admitted that in his entire career that he had never seen a homicide investigation where the medical examiner could not determine the manner of death, but he remained undeterred in his quest to charge Miss Reed. As he later admitted, the medical examiner's refusal to rule the death a homicide did not matter to him because either way, Miss Reed was going to be charged. Quote unquote. Proctor made his investigation cut and dry by manufacturing a case against Miss Reed. A crucial first step was to ensure that the crime scene and evidence was not secured. This was in violation of MSP policy and well-established best practices for critical incident investigations. Specifically, the MSP Crime Laboratory requires proper processing of evidence at major crime scenes, including crime scene photography and evidence processing, and a recovery of latent fingerprint, footwear, and tire track evidence. Neither the MSP troopers involved in the investigation nor CPD police officers on the scene secured the Alberts' home or the area where Mr. O'Keefe's body was found. The MSP did not take any photographs of the house, including any part of the yard where Mr. O'Keefe's body was found, until February 1st, more than 3 days later. No photographs were ever taken of the inside of the garage at 34 Fairview. This intentional departure from established protocols permitted Proctor Buchanan to generate false incriminating evidence against Miss Reed and give the House defendants time to destroy the actual evidence. We're on page 26 out of 54. By approximately 2:30 p.m. on January 29th, before he had even met or interviewed Miss Reed or even seen her Lexus SUV, Proctor had already ordered seizure of the vehicle at her parents' home in Dighton. By 4:17 p.m., the vehicle was in the MSP's physical possession. The vehicle was then towed to the CPD Sallyport, even though MSP was at least two, although, even though the MSP, Massachusetts State Police, had at least two closer barracks, including Middleborough and MSP headquarters for accidental reconstruction, and where the vehicle would ultimately reside for analysis. And Massachusetts was in the middle of a historic nor'easter blizzard. Proctor knew he had mere Proctor knew he had more leeway to manipulate evidence regarding the SUV at CPD and that MSP facilities, and he knew he needed to have that evidence in close proximity to the crime scene at 34 Fairview. Did he? Did he really? Before the vehicle arrived at the garage, Miss Reed's Lexus taillight had a minor crack but was intact, an observation ultimately testified to by Dighton officer Nicholas Barrows, who was never interviewed by Proctor or any member of the MSP. The crack occurred when Miss Reed backed into Mr. O'Keefe's car at 5 a.m. that morning as she was leaving to search for him. The incident was captured on video. For nearly 2 years, however, Proctor memorialized the event as Miss Reed's Lexus coming close but not hitting Mr. O'Keefe's Chevy Traverse. Chevy Traverse. Proctor ultimately changed that narrative to admit the vehicles did come in contact with each other. Buchanan Proctor followed the vehicle from Dighton and arrived at CPD at 5:35 p.m., just moments after the tow truck with the Lexus. At some point after the vehicle arrived at the Sallyport, the right rear taillight was almost entirely destroyed. Video taken from different angles at the Sallyport shows Buchanan, Proctor, Canton Police Chief Ken Berkowitz, and other individuals near the taillight. But notably, no video captures the taillight's appearance at the precise time it arrived at the Sallyport. The available surveillance video from the Sallyport, as well as CPD Access card swipe log obtained by a separate law enforcement agency, the FBI, revealed seemingly unfettered access to the Sallyport by a myriad of individuals, including Brian Higgins, throughout the evening of January 29th, including just before and just after 5:30 p.m. One or more of them destroyed the taillight, secretly took pieces of it into their possessions, and then planted some of them in the various places at 34 Fairview and on Mr. O'Keefe's clothes. Knowing that there was video cameras both inside and outside the Sallyport, Proctor and Buchanan worked together to obscure their role in manipulating the right rear taillight, and then, ultimately, to present false evidence at the first criminal trial. Specifically, Proctor directed Buchanan to secure video footage from the surveillance camera located both inside and outside the Sallyport garage, which he did. These videos were manipulated in two significant ways. First, a critical 42-minute portion was deleted from the footage from the Sallyport front wall camera, the portion from 5:08 p.m. to 5:50 p.m., which included the exact time Miss Lexus arrived in the garage and the period Proctor was at the passenger side taillight. This footage would have shown that the taillight was intact. Second, footage from the Sallyport back wall camera was inverted, which made the right side of Miss Reed's vehicle appear to be the left side, and vice versa. Another camera, main driveway side exterior, captured the back end of the Lexus as it arrived at CPD, but was too grainy to decipher the condition of the passenger taillight. The videos from inside and outside the Sallyport, and Proctor's request for Buchanan to obtain it was intentionally hidden from Karen Reed and her defense attorneys for more than 2 years to avoid scrutiny. The video was then sprung on them immediately before and during the second criminal trial. One driveway camera footage was not revealed to the defense until just prior to the start of the second trial. In fact, Buchanan presented one part of the video during his direct testimony under questioning by the Assistant District Attorney, Adam Lawley. Buchanan narrated the video to the jury, correctly identified that Proctor was at the rear of the vehicle, but claimed that he had never approached the right rear taillight area of the vehicle. That testimony, however, was entirely false. And as we well know, the video that Buchanan authenticated as a fair and accurate was actually neither fair nor accurate because it had happened to be inverted. Proctor was actually behind the right rear taillight for a significant period, but because it was inverted, it appeared in the video that he was behind the left taillight. They hoped this would allow Buchanan to lie about this issue at trial without detection. But this video and Buchanan's false testimony, the MSP, Proctor, and Buchanan attempted to mislead the jury in order to conceal the tampering with and planting of the taillight material. Oh boy. So now they're claiming that Buchanan had access to this and that he also planted evidence. Interesting. Very, very interesting. My camera is slightly tilted, so I'm going to just tilt it a little bit more. There we go. All right, people, we are on page, I think, 29 out of 54. We are still a long ways away. I hope you're doing well. All right, here we go. Proctor and Buchanan took taillight pieces from the Sally Port, brought them back to 34 Fairview to plant them in the location where Mr. O'Keefe's body was found. Interesting. And a warrant applications to the Stoughton District Court and Norfolk Superior Court for searches of Google electronic records, ring videos, Miss Reed's phone, Miss Reed's vehicle, cell tower records, and other sources of information. Proctor swore he seized Miss Reed's vehicle from her parents at 5:30 p.m. on January 29th and had the vehicle towed to CPD. Reports shared by the Dighton Police Department revealed that the Lexus was towed from Dighton at 4:17 p.m. Proctor's assertion that he seized it at 5:30 was intentionally false to hide the fact that the car was in police custody for 73 minutes longer than indicated in his sworn affidavit. Proctor maintained that false narrative because it would hide the exact time frame when he had the opportunity to remove the pieces of the taillight from Miss Reed's vehicle and bring them back to the house so that he could later claim the pieces had never been there since approximately 12:30 a.m. on January 29th. However, unbeknownst to him, driveway video from the Reed residence in the Dighton and a report written by the Dighton police officer revealed Proctor's lie and revealed the truth and accurate time the Lexus SUV came into MSP's possession. Proctor also deposited the SUV's taillight pieces that he had otherwise removed from the vehicle in the Sally Port on Mr. O'Keefe's clothes. Proctor retrieved Mr. O'Keefe's clothes from the floor of the hospital where he was pronounced deceased. Instead of securing the clothes in a sealed container or a bag, as protocol requires, Proctor and Buchanan drove them around in his car all day and then placed them in the Norfolk County District Attorney's Office for at least 6 days, where they were accessible to Proctor, Buchanan, and other MSP troopers. In his trial testimony, Buchanan asserted that both he and Proctor were at the Norfolk District Attorney's Office, drying out O'Keefe's clothes, putting clothing on butcher paper well into the evening, at least 8:30 p.m. on January 29th. But in front of the MSP trial board on March 2025, Proctor testified that he arrived back home at 7 p.m. that night. Furthermore, Proctor stated that he went from a debrief at CPD straight home and never mentioned visiting the Norfolk Attorney's the NDAO, the Norfolk District Attorney's Office, with Buchanan and handling any key items of evidence, despite Buchanan's claims that Proctor was handling the clothing that night. On these matters, Kennick and Proctor's sworn statements significantly differ and cannot both be true. Proctor and Buchanan also failed to create a log to document the chain of custody of the clothing. Therefore, and by design, there is no record of when, how many times, and under what circumstances Proctor and Buchanan touched, manipulated, handled, and otherwise tampered with the clothing. The MSP Evidence Submission Handbook dictates the chain of custody begins at the time of the collection and that the collector seal evidence packages as soon as possible after collection to ensure integrity of evidence items and limit loss of transient evidence. Now, to their defense, though, his clothing was saturated with water from snow, but somebody did testify what the procedure is if you have wet clothes and is not to lay on the butcher paper at the Norfolk District Attorney's Office. Here, in violation of the MSP's stated policy, the chain of custody for all of John O'Keefe's clothing, as well as a dozen pieces of taillight material, does not begin until March 14th, nearly 2 months after it was collected when Proctor finally submitted it to MSP Crime Lab. At some point before providing these clothes to the crime lab, Proctor and Buchanan placed these pieces of the SUV taillight on them, where they were then identified by the crime lab in 2023. A year later. Proctor also planted pieces of glass on the bumper of Miss Reed's SUV while it was in his possession at the CPD's Sallyport garage, which it then claimed to have recovered later on February 1st. Proctor planted this evidence. Proctor also planted I'm to recover later. Proctor planted this evidence to make it look like these shards originated from a cocktail glass that Mr. O'Keefe was holding when he exited the Waterfall bar. Evidently, Proctor did not plan on Karen Reed's defense attorney insisting on forensic testing of the glass shards, which showed that they did not match the cocktail glass in Mr. O'Keefe's possession. In fact, the 5 glass pieces originated from multiple different sources. One shard of glass on the bumper did not match another piece of glass that had been in Proctor's possession during the investigation. The only way for the glass to have ended up on the SUV bumper is that Proctor planted it there in an attempt to connect the vehicle to the death of Mr. O'Keefe. Wowzers. Oh my goodness gracious. So far, what do you think? Do you believe that this is all true? Now, mind you, this is a motion that was given by Karen Reed civil attorneys. So we'll see. We're going to pause here for a moment.